Right before coming to the Department of Education, Ms. Lhamon was the Director of Impact Litigation at Public Counsel, which is the nation's largest pro bono law firm. Before going there, she practiced for a decade at the ACLU of Southern California, ultimately as Assistant Legal Director. Prior to that, Ms. Lhamon was a teaching fellow and supervising attorney in the appellate litigation program at Georgetown University Law Center after clerking for the Honorable William A. Norris on the U.S. Court of Appeals for the Ninth Circuit. She received her JD from Yale Law School, where she was the Outstanding Woman Law Graduate, and graduated summa cum laude from Amherst College. Assistant Secretary Lhamon, we are so privileged to have you here with us today. I want to just extend, on behalf of the National Women's Law Center, a welcome to you to the Department of Education's Office for Civil Rights. We're so happy that you're on board, and we are honored to have you with us today.
Thank you so much, Lara. I'm delighted to be here and to be on board, and I'm just thrilled that we have this webinar going on. The National Women's Law Center has been a terrific resource for civil rights and for the Office for Civil Rights, and I'm so grateful to you for hosting this webinar. Obviously, supporting pregnant and parenting students is an issue that's very important to us here at the Department of Education and at the Office for Civil Rights. The President set a goal that by 2020, the United States will lead the world in the portion of persons who graduate from college, and supporting every student in completing high school and being prepared for college and career is critically important, and that includes supporting our pregnant and parenting students in our schools. We've seen examples of ongoing discrimination against pregnant and parenting students even since the passage of Title IX in the last 40 years, and those examples are enormously disturbing. They include a college student who was told she had to leave her school's nursing program because she was pregnant, high schools and colleges refusing to excuse absences from pregnancy or from childbirth to allow students to make up work missed due to those absences. A pregnant high school student was told she couldn't run for her school's homecoming court, and a pregnant high school student was not allowed to go on a school choir trip to Washington, D.C. Those kinds of examples of ongoing discrimination against pregnant and parenting students demonstrated for us at the Office for Civil Rights a need to put out more guidance to make sure that recipients understand what their obligations are with respect to pregnant and parenting students. And so in June of 2013, we released a Dear Colleague letter and an accompanying pamphlet that focused on supporting the academic success of our pregnant and parenting students. And I know you'll hear more about the information from that pamphlet and Title IX's requirements later in this webinar, but I just wanted to take time personally to say on this call how committed we in the Office for Civil Rights are to helping all students graduate from high school and college, and that we appreciate the work each one of you is doing to help us in this effort, and we look forward to continuing the vital partnership. And just thank you so much. I'm going to turn it back to you now, Lara.
Thank you. Thank you so much, and keep up the good work. We're very happy today to have a couple of Catherine's colleagues here with us. We have John DiPaolo, who is the Deputy Assistant Secretary for Policy at the Department of Education's Office for Civil Rights, as well as Rachel Gettler, who is a staff attorney with OCR as well. And we thank you both, as well as Ms. Lhamon, for your time working on this issue and being with us here today. Before I turn it over to John and Rachel, I wanted to just ask my polling question. Amy, do you have that?
Yep, just pulled it up.
Okay.
So if everyone could just answer which you're most affiliated with, we'll give it another few seconds.
Yeah, there are 4 options, really 5 options. Are you affiliated with a K-12 school system, with a post-secondary institution, with an advocacy organization, a government agency, or other? We just wanted to get a sense of where folks are coming from today before we get into the meat of the presentation. So it looks like we have almost equally split between K-12 and post-secondary institution, and then a good number of people from government agencies and advocacy organizations as well. So we have a real mix today, which is great. John and Rachel, take it away.
Great. Thank you so much, Lara, and thanks to the National Women's Law Center for hosting this, and to all the participants. We really appreciate the fact that you're paying attention to this issue and that you're giving us the chance to talk with you about the guidance we put out, because we do feel that it's very important. We released our letter and the pamphlet in June of this year, and our objective is to clarify how the Title IX regulations apply to pregnant and parenting students. We put those documents out along with a short Know Your Rights document, and that document's actually aimed at pregnant and parenting students. So we're hoping that what we've put out is a variety of documents that are going to be useful for different audiences and very accessible to both practitioners in education as well as students themselves, parents, families, because we think this is an issue that everybody ought to know about. We think that this situation gets better the more people understand the rights of pregnant and parenting students. The links to our various documents are on this slide, so please take note, and these things are all pretty easy to find on the ED website. The pamphlet that we just released replaced one that OCR issued in 1991, and our pamphlet discusses all the Title IX requirements related to pregnancy and parenthood, including the rights of pregnant and parenting students to fully participate in school. Although the pamphlet focuses on secondary schools, the legal principles apply to all recipients of federal financial assistance, including post-secondary institutions. One thing that's new about the pamphlet is that it includes a frequently asked questions section to give examples to help schools understand their obligations and help pregnant and parenting students understand their rights. There are also additional suggestions for administrators, teachers, and counselors to assist them in supporting pregnant and parenting students. And finally, the document includes an expanded section on programs designed to support pregnant and parenting students with examples of promising practices that schools may choose to implement. The basis for our letter, of course, is Title IX. And Title IX lays out, most significantly, a very straightforward and very powerful principle and requirement of non-discrimination, that no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal or financial assistance. There are a couple principles that run through the guidance, and I want to articulate those and say that if, there's a lot of detail in the pamphlet. We're going to go through a lot of detail today, and there are resources out there to allow you to return to that detail and get into it as you need to. But if you take anything away from our conversation today, I hope it'll be these overall principles. First of all, pregnant students have a right to be in school. And secondly, schools should work with pregnant students to help them succeed in school and to graduate. And I think those are not, those are legal requirements, but those are also basic educational commitments that I think all of us can support. And in doing so, we're going to do a world of good for pregnant and parenting students. I'm going to turn the rest of the presentation over to my colleague, Rachel Gettler. And I want to recognize Rachel as the lead attorney in drafting the guidance that we just put out. And she's done a fantastic job and worked extremely hard on it and brought to it a lot of depth and a lot of great thinking and also a lot of great learning that we've tried to bring in from a range of people in the field that we've worked with as we've generated these documents. So let me hand the conversation over to Rachel.
Thanks, John. And I'm going to get into a lot more detail of the Title IX regulations and specifically what they require. As you can see on this slide and the next slide, we have set out the specific Title IX regulations that relate to pregnant and parenting students. You can see basically the Title IX regulations specifically prohibit discrimination against a student based on pregnancy, childbirth, false pregnancy, termination of pregnancy, or recovery from any of those conditions. And the Title IX regulations also prohibit schools from applying any rule related to a student's parental status that treats students differently based on their sex. So I just want to point out these two slides, this slide and the next slide. You'll notice that these are a paraphrase of the regulations, and so where the language on these slides refers to pregnancy, keep in mind that the regulations also cover conditions related to pregnancy, like childbirth. So moving along to the regulations and how they relate to classes and school activities on the next slide. First, basically, schools must allow pregnant students to continue participating in classes and extracurricular activities. This would include advanced placement and honors classes, also includes school clubs, sports, honor societies, student leadership opportunities, and other activities such as after-school programs if they're operated by the school. And you can see these set out on the next slide, slide 6. There we go. Schools also must not require pregnant students to submit a doctor's note to participate in school or in extracurricular activities unless they require a doctor's note for all students who have a condition that requires a doctor's care. Related to that, schools also must not require a doctor's note from a student who has been hospitalized for pregnancy or childbirth unless it requires a doctor's note from all students who have been hospitalized for other conditions. Schools may implement special instructional programs or classes for pregnant students, but participation in those classes must be voluntary, and the programs or classes must be comparable to those offered to other students with regard to the range of academic activities they offer, the range of extracurricular activities they offer, and the range of enrichment opportunities they offer. So you can't have separate programs for pregnant students that only offer career and technical education programs if your regular education program also offers access to AP and honors classes. And also it's up to the pregnant student to determine whether or not she wants to participate in that separate program. Finally, on classes and school activities, to ensure pregnant students' access to the educational programs, schools must provide pregnant students with reasonable adjustments, like could be larger desks, elevator access, frequent trips to the bathroom, when those reasonable adjustments are necessary because of the student's pregnancy. Moving along to pregnant students and excused absences and medical leave. First, schools must excuse absences due to pregnancy or childbirth for as long as the student's doctor deems it medically necessary. It's up to the student's doctor to make that determination, not the school. Students who miss school due to pregnancy or childbirth must be allowed to return to the same academic and extracurricular status as before their medical leave began. And for that to be possible, those students should be given an opportunity to make up any assignments or exams that were missed while the student was absent. Related to this, schools must ensure that teachers understand the Title IX requirements related to excused absences and medical leave that I just talked about. They have to make sure that their teachers understand that. Teachers are not allowed, may not refuse to allow students to submit work after a deadline that the student missed because of pregnancy or childbirth. If a teacher's grading is based in part on class participation or attendance and the student misses class due to pregnancy or childbirth, that student should still be allowed to make up those participation or attendance credits. And finally, schools must provide pregnant students with the same special services they provide to students with temporary medical conditions. That would include things like homebound instruction, at-home tutoring, independent study. Moving along to harassment and how that affects pregnant parenting students. As some of you probably already know, Title IX prohibits harassment based on sex, and this includes harassment because of pregnancy or related conditions. Some comments that could constitute this prohibited harassment would include making sexual comments or jokes about a student's pregnancy, calling a pregnant student sexually charged names, spreading rumors about a pregnant student's sexual activity, or making sexual propositions or gestures. Schools must take prompt and effective steps reasonably calculated to end pregnancy-related harassment, prevent its recurrence, and eliminate any hostile environment that has been created by the harassment. And a school violates Title IX if that sexual harassment or other pregnancy-related harassment by a student, employee, or third party is sufficiently serious that it denies or limits that pregnant student's ability to benefit from or participate in the education program, and the school encourages, tolerates, or doesn't adequately address the harassment. Moving along to the 3 policies and procedures that Title IX requires all schools to adopt. can see the policies and procedures are set forth on this slide. Just for the purposes of this slide, I just want to, before we go into the detail, this slide says school here. Just so you know, the school here refers to a school district or a post-secondary institution. So in other words, a school district is expected to put these policies and procedures in place for all its schools, and then each post-secondary institution must have these policies and procedures. So the first one is schools must publish a notice that they don't discriminate on the basis of sex in their programs and activities. Now, OCR doesn't require specific policies prohibiting discrimination against pregnant and parenting students, but we certainly do recommend that schools' general non-discrimination policy make clear that sex discrimination covers discrimination against pregnant and parenting students. Second, schools must adopt and publish grievance procedures so that students can file complaints of sex discrimination, and that would include discrimination related to pregnancy or parental status. Finally, schools must designate at least one employee to coordinate its efforts to comply with Title IX. This person is often called the Title IX coordinator, and the responsibilities of this person include overseeing complaints of discrimination against pregnant and parenting students. Finally, I just want to conclude by reminding you of the basic principles that we talked about earlier that John mentioned. Overall, pregnant students have a right to be in school, and schools should work with pregnant students to help them succeed in school and help them graduate. I also want to let you know we have some contact information on this slide for OCR and also an online complaint form. I want to let everyone on the call know that you should feel free to ask OCR for help at any time. We know that this can be a complicated issue, and we're more than happy to provide technical assistance to schools, students, advocacy organizations, and schools especially should keep in mind that you can ask OCR for technical assistance on this topic without worrying that you're inviting us to come and start an investigation of any type. If you want to get technical assistance from OCR, you can contact the OCR regional office that serves your state. You can see I have the number you can call to find that out, or you can click on the link that's on the slide. Second, if you're someone who is a pregnant and parenting student or related to one, or you know one, and you believe that the school is violating Title IX and you want to file a complaint with OCR, on this slide you'll see we have a link to our online complaint form. So now I'm going to go ahead and turn it over back to Lara to continue the rest of the presentation.
Thank you, Rachel and John. That was really, really helpful, and it's just so great to have you with us and to know that the Department of Education is making this a priority. And now I wanted to talk about why this guidance was so needed. You know, these regulations have been around since the 70s. Title IX was enacted in 1972, but violations are still happening all over the country. And what this guidance does is it reminds schools of their obligations and helps clarify exactly what we mean by equal educational opportunities for pregnant and parenting students. John mentioned the FAQs that are in the guidance. Those are extremely helpful. They address a lot of the questions we get in our work from people all over the country who are experiencing discrimination or think they might be. And we also get questions from schools about whether or not what they're doing complies with Title IX. So that's going to be a terrific tool for people, and I encourage everybody to take a look at those. The discriminatory barriers that pregnant and parenting students still face include, I've sort of lumped them into 4 different buckets here. The environment of discouragement that many of them are met with, punitive absence policies, being steered into unequal alternative programs, and then inaccessible homebound services. So I wanted to address those in turn briefly with just some examples of the kinds of discrimination we hear about. We hear that pregnant and parenting students, once it becomes known that they're pregnant, are treated differently, and people start to talk about them in a different way or make assumptions about them, largely based on stereotypes. And those assumptions can be internalized by young mothers and can affect their belief that they can actually achieve their goals and may, in fact, push them out of school, in addition to all the other barriers they face, including a lack of guidance and support and encouragement from the adults in their lives, many of whom they encounter at school. So there are a number of examples of these. One case that made the news in Delhi, Louisiana, was a case that required any students suspected of being pregnant to submit to a pregnancy test, and any students who did test positive for pregnancy were told they could no longer come to school and had to learn from home. It's such a blatant example. It's hard to believe that that was really happening in 2012, but it was. And thanks to the ACLU, we learned of that, and the school got their act together and changed that policy. There's another case in New Mexico that the ACLU is still handling, where a student was kicked out of school for being pregnant, and the ACLU told the school that that was not acceptable, not legal. So the student was allowed back in, but then the school called a school-wide assembly at which they humiliated the student by requiring her in front of the whole school to announce that she was pregnant. Things like this are still going on. Some of them are more subtle. Sometimes students are just constantly met with harassment by their peers or comments from their teachers that are not addressed the way they should be by schools, and they get the message that they don't belong. But some of these blatant barriers still exist. Students who make it all the way to graduation but then are told they can't walk at graduation because it reflects poorly on the school. There was also, in the last several months, in the news, there was a story about a student who was pregnant and was not allowed to be pictured in the yearbook. There are many federal court cases about National Honor Society chapters trying to exclude eligible students who at one point had been pregnant or who currently are pregnant, and courts have said that is not legal. So the other thing we hear about a lot is really rigid application of rules and disciplining of students in an excessive way for things that are hard to avoid. For example, a young woman who no longer fits into her school uniform because she's pregnant should not be threatened with detention. That has happened. You know, the school should either help this student get access to a uniform that does fit or make an exception to the policy because of the situation the student is in. I've heard of another school where security guards were turning students away at the door who weren't dressed in uniform, but these were pregnant students who couldn't fit into their uniform. And as an education policy advocate, to hear that students made it all the way to school, found some child care for their students, got themselves to the building, and were turned away at the door is just so upsetting. It's exactly what should not be happening. So hopefully schools are getting that message now. In some places, there is a sort of automatic system that when a student gets to a certain number of absences, they are automatically put into truancy and referred to truancy court. And that is really unfortunate because obviously not all absences are created equal. When states don't have clear policies on what absences are excused and aren't, there can be a lot of misunderstanding. But as John and Rachel explained, any pregnancy-related absences have to be excused for as long as a student's doctor says is medically necessary. And when students don't know they have these rights in many, many cases. So these students end up pushed out of school or in alternative schools for students with discipline problems when, in fact, all of that could have been avoided. There are some states that have clear policies on excused absences, and I've listed those here. Of course, there's also the problem of unequal alternative schools. Whether a school is equal in quality or not, really students should have the choice whether to go to an alternative program. They should not be steered or pushed into those programs. Unfortunately, the problem with separate programs is that sometimes they are not offering the same range of academic and extracurricular opportunities that a student would have in her mainstream school. And the most extreme example of this is the New York City P schools. They were closed down in 2007, but they did not have good attendance. Students were not earning credits. They weren't getting job skills. They weren't getting college ready, and they were doing quilting instead of geometry or in place of geometry. Homebound instruction is a fabulous tool for helping students stay on track and stay in school. There's no requirement under Title IX that a school system offer homebound instruction, but if a school system offers it for a student who's temporarily disabled with another medical condition, they need to make it available on the same basis for pregnant and parenting students. And for obvious reasons, there's going to be some period of time where a pregnant or parenting student cannot attend school, either because they're on bed rest or they're recovering from childbirth, whatever it may be. And during that time, it can be extremely helpful if they get homebound instruction. At a minimum, schools should be sending work home to students, but that's not even happening in a lot of places. But here, you know, some states mistakenly had rules that said pregnancy is not an eligible condition for their homebound instruction programs. And I believe Michigan and Georgia were the only two states where that was a problem, and that has been corrected. North Carolina has a much more progressive law saying that schools have to offer homebound instruction for students, not only students who themselves are pregnant or recovering from childbirth, but students whose children have illnesses or who can't come to school because they don't have access to child care. And that's really important because parenting students very quickly can rack up a lot of absences when their children get sick and can't go to child care. And we don't want them, you know, giving up on school just because they're facing those kinds of challenges. So I'm now going to talk about some of the Title IX problems that we hear about at the post-secondary level, and we are so lucky today to have with us Stephanie Stewart, who was a student at the Borough of Manhattan Community College until recently. She's now a student at NYU, and she filed a complaint with the Office for Civil Rights based on discriminatory treatment that she experienced, and she's here today to tell us about it. So Stephanie, if you'll just take a few minutes and tell us about your story, we're excited to hear from you.
Thank you so much, everyone, for giving me this opportunity to express what I went through regarding to my pregnancy in the university in which I was attending. At the time of my school attendance, I was an honor student who had received a scholarship, and I was one out of 8 students chosen for great academic achievement, which was prior to the semester which I was attending at the time. So when May approached, and actually it was around March, and I was about 7 months pregnant, and I had started school. I knew that it was something I could handle as a pregnant woman, and especially since my academics was up to par. So on the first day of classes, I went to the introductory classes, and after each class, I would approach the professors and let them know about my condition, that I was pregnant. I in no way wanted any type of favoritism, but I did want to let them know that at some point I would be admitted to the hospital for labor and delivery, and during that time, if they could give me an opportunity to make up any work missed. Out of the 4 classes that I was attending, three professors, they were very accommodating and understood my situation, and they were willing to work with me so that I would stay on track with my academics. But there was one particular professor who unfortunately did not treat me the same. During her first class, she did go over her policies of what she expected out of every student, and she did mention that there were certain things as far as attendance that she would not accept. And one of those was absences that had no type of justification. She said once you are absent, that is pretty much on your record, and that is how she will grade you. I then lifted up my hand in class and asked her just a general question, if she would accept or just any student's medical documents that would justify their absences. And right there in that moment she said absolutely not. So at the time I felt it would be more appropriate if I sent her an email, which I did. And on the email I let her know that I was pregnant, and at some point I would be going to the hospital for labor and delivery. Could she possibly accommodate me during that time period? And she immediately responded, and she gave me a response that I was not expecting at all. It was pretty much a shock factor. She said, absolutely, under no circumstance would she accept any type of medical documentation to justify me being in labor and delivery. And the bottom line was it would affect my grade. So I had two options, to either stay in the class and jeopardize my grade, or I could leave the course and drop the class and maybe get another class, or just leave the course in general. And that type of reaction at the time was not a reaction I was expecting, because as a person who is knowledgeable about the rights that were fought for women in order to obtain an education, at that given time, it felt as if my right was being taken away from me. And so I approached my scholarship coordinator, and I let her know that my professor was denying me from making up any classes. And she immediately said, what the professor says is what I need to accept. And those are the rules, because each professor is in charge of their own class, and they make pretty much their own policies. And for some reason, I couldn't understand how a few of the professors were accommodating to my situation and would allow me to make up any missed works or make up any tests during my absence, and yet one professor was opposed to that. So I spoke to my husband, and he said maybe I should follow the chain of command and maybe speak or file a complaint with the dean, somebody who's above the professor. And so I had sent the dean an email letting him know about my situation, and that I am a very diligent student who wants to continue my education. I don't want to jeopardize it in any way because I am pregnant, and that I am a scholarship recipient, and could he possibly find a way to accommodate me or work something out with the professor. And unfortunately, once again, he just said, absolutely not. If I'm pregnant, I have, again, those two options. It's either I stay and jeopardize my grade, or I can just drop the class. And those are the two options I have. It's either you take it or you leave it. And at the time, I was very disappointed. I was going through a pregnancy, and it was just emotionally difficult. And so I spoke to my husband, and he couldn't accept the fact that how can a woman who is pregnant be denied to continue their education just because they're pregnant. And so ultimately my scholarship was taken away from me, and I had no option but to drop the course in which I was registered under. And ironically, the course which I was registered with was a woman's roles course, which ironically spoke about the discriminations that women faced historically through different cultures, and what they had to go through in order to gain their rights, even through education. And unfortunately, this professor who was teaching that course just seemed to deny me that very right, which she knew women had struggled to obtain for so long. Nevertheless, my husband and I decided to just research on the computer. At the time, I wasn't aware of Title IX and what it entailed. Nevertheless, when I did find it on the internet, there were the regulations which were spoken about today. And the moment I saw it, I thought, bingo. I knew that somewhere I had a right. And my husband and I decided to file with Human Rights, and the procedure was followed. Unfortunately, it was dismissed because they said that I was out of jurisdiction. And again, I felt like the door was being closed in front of me, and somehow I wasn't getting the help that I needed. Nevertheless, my husband encouraged me to keep just looking and researching, trying to see where I could find a voice. And surely enough, I found the Women's Law Center. And I sent them an email letting them know of my situation, and I explained it from A to Z, and they were extremely helpful. And they explained the entire law to me, and that without a doubt I was violated and discriminated against and denied the opportunity to continue my education. And it was only through there.
I'm so sorry to interrupt. Go ahead.
No problem. No problem. And I'll end it with this. It was only through their intervention that I could find some relief in my situation. But once again, thank you so much for giving me an opportunity to give a voice to not just myself, but to pregnant women, and to show that this issue is still continuing. And I'll hand it back to Laura and let you know, and I'm sure she'll continue.
Thank you.
Thank you very much.
Thank you, Stephanie. That was so interesting to hear from you. And I just jumped in because you started to mention the National Women's Law Center's involvement, so it seemed like an opportune time. But thank you for your willingness to share that with us, and also for your willingness to speak up on behalf of yourself and other pregnant students at in the CUNY college system. Because as a result of Stephanie's willingness to stick her neck out, we filed a complaint with the Office for Civil Rights against CUNY, and we were able to come to a settlement that was really groundbreaking, and we got some individual relief for Stephanie. We got her scholarship back. We got her re-enrolled in to get the credits that she needed, and that she wouldn't have to pay again for courses that she, credits that she had already paid for in the class that she was not allowed to take. But we also, CUNY agreed to make some policy changes to apply to all of the colleges in their system across Manhattan, all 5 boroughs, and they serve over 250,000 students every year. They adopted a policy memo on Title IX and pregnancy, and that memo was sent to all faculty and staff, to all the legal departments at their colleges, to student affairs departments, academic departments, etc. Something went on the website about it. There's something in student handbooks about it. And all of the Title IX coordinators and directors of student affairs were going to get training on the new policy. And all future Title IX trainings for faculty and students are going to include information about Title IX and the school's obligations to pregnant and parenting students. So it was really a great outcome, and one that we hope will be an example to other colleges and universities and post-secondary training programs. Other problems that we've encountered, and I'm going to go through this quickly because I want to make sure we have plenty of time for questions. These slides are going to be available to all of you. You will get an email after the webinar that contains a link to these slides, so you can look through them at your leisure. I don't want to go through every single example, but needless to say, we have seen this in all different types of programs, community colleges, four-year universities, for-profit colleges, vocational training programs, and we have seen it in graduate schools as well. There's just either a concern that students shouldn't be working in certain fields when they're pregnant, a concern, and some of that is based on old stereotypes that are no longer valid. Even when a student's doctor says it's okay for her to stay in a program, we see schools saying that they don't think it's okay. But again, schools can't second guess the judgment of a student's doctor. We have seen schools unwilling to excuse absences at all, or unwilling to allow students to make up work they missed for those absences. Schools saying, well, we'll excuse the absence, but you're still going to lose participation points for not being here. If you're not allowing a student to make up work she misses when she's absent due to pregnancy or a related condition, and she's being penalized for not being in class during those times, then you're essentially not treating it as an excused absence, and that violates the regulations. So we see a lot of examples in nursing programs, and unfortunately, some programs, even where a student doesn't have any restrictions, will say that she can't be in the program. On the flip side, we'll see students who do have some restrictions from their doctor, like no heavy lifting, for example, and the school's unwilling to accommodate any restrictions at all, which can also be a problem. Surgical tech program, this was a very distressing example where a student was okay to work and the school wouldn't find her a placement, a clinical placement, because they said that she shouldn't be working when she was pregnant. Now, if a student wants to come back very quickly after pregnancy, which, you know, some students do want to do, can the school say, no, you really need to take more time off than that? We have heard that question, believe it or not. And our answer to that is that you should treat her as you would any student who's absent for medical reasons. So just the same way you leave it up to students and their doctors to decide how long they need in order to recover from their medical condition, you also have to defer to their judgment if the student thinks she's ready very quickly to return to school. You can let her know that there's more excused leave available to her, but you can't force her to take it just because you think it would be better for her or her baby. And as Rachel and John explained, you can require a physical a note from a physician or a physical exam in order to clear her to come back to class, only if you require that of all students who have temporary medical conditions. And so the question is, when a student's absent for only 3 days because he or she is sick, do you usually require a note in order for them to return? Because that would be the comparable situation. We hear a lot about lactation concerns, and that is something that we think is very serious because there are medical consequences to not expressing milk on a schedule when a student's lactating. It can affect their ability to learn in class. It can send students the message that being a mother is incompatible with staying in school. And we know now in the employment context there's a lot that employers are required to do in order to accommodate lactation needs, and we'd like to see schools move in that direction because it is a related medical condition. But Title IX is a floor, and we know that there's a lot more schools should be doing and can be doing to support pregnant and parenting students. The guidance from the Department of Education does make suggestions about that. They have lists of things that administrators can do, things teachers can do, and things that counselors can do to help support pregnant and parenting students, and they talk about the type of programs that are helping these students succeed. Here's just a few examples of promising programs we're aware of. There are programs that we're not aware of, I'm certain, but here are some links if you want to find out more about these programs. And if you learn of discrimination, as Rachel and John said, you can reach out to one of the regional offices for the Office for Civil Rights. You can file an OCR complaint, but there are some interim things you can do as well. You can try to contact the school's Title IX coordinator. You can try to reach out to someone in the administration of the school. You can look at our website. We have a lot of fact sheets and resources for students that sometimes they find useful in advocating for themselves. And you can also call or email us for help, because we do sometimes, you know, we can't represent every student who comes our way, but we are happy to share information with people and help them either advocate for themselves, find a referral to someone who can help them, or in some cases we can intervene and directly help them. So thank you so much for your time. I would like to open it up now to questions. You can ask questions of any of us on the call, John and Rachel from OCR, Stephanie Stewart, and myself, and we really appreciate your attention today. Amy, are you getting any questions?
Yes, I have lots of questions. And we're going to start with just kind of a technical OCR question. When you file with the state, how does that interact with the federal level of OCR? A number of folks from different states have asked how that works.
Thanks, Amy. This is Rachel. I wasn't sure when. I think maybe the confusion was because I was talking about our state OCR. Our OCR office is responsible for your state. That is part of federal OCR. We have 12 regional offices throughout the country. Those regional offices handle all of our enforcement work. So when you file complaints, you file them with one of those regional offices, whichever regional offices serves the state where your school is located. So that's how that works, but they are considered part of federal OCR, and they interact with us. We are in main headquarters here in DC. They interact with us as well. So it's not like filing with maybe a human rights office in your state, like Stephanie had mentioned she had done, or in your city. This is filing a complaint for OCR is through federal OCR, even though they're handled by our regional offices.
Great. Thanks for clarifying that, Rachel. And another question, if one of you could provide examples, either real or hypothetical, of parenting students, so maybe students who have already given birth and how their absences were excused or maybe weren't excused, just to provide some context in that situation.
I can talk about that from OCR. The main bulk of the Title IX regulations covers pregnancy and related conditions. And then there's that separate regulation I talked about for parenting students. And that basically says you can't apply a rule related to parental status that treats students differently on the basis of sex. So how that plays out with excused absences is if you're a parent and say you want to take time off to care for your sick child. If the school allows that for mothers, for female students who are parenting, to have excused absences to take care of their sick child, they would have to allow the same for male students who are parenting. But unfortunately, the school would not be required if they said no parents can have excused absences for taking care of their sick children. They're not required as long as they apply that equally to male and female parents. We certainly encourage and strongly recommend to schools that they should excuse absences for parents to take care of their sick children, to take their children to doctor's appointments. That's something that we certainly support in OCR and we recommend and encourage, because we need to make sure that the parenting students stay in school and that they're able to graduate school, graduate college, ready for a career.
Great. Thank you again. Our next question is, a number of folks have asked, and you touched on this a little bit, but are districts required to have Title IX coordinators at the K through 12 level? And who do you go ask if you're not sure who that person is, and if one doesn't exist, then what do you do?
Yes, all districts at the K through 12 level are required to have Title IX coordinators. The key thing is each school is not required to have its own Title IX coordinator, so the Title IX coordinator for the district would be responsible for Title IX issues going on at all schools within that district, so long as the district is a recipient of federal financial assistance, so all public K through 12 schools. The best place to go is hopefully you could check out your school district's website. You can do a search in there for Title IX coordinator. It might be called something like equity coordinator, or it might be something under human resources. Often is the office where the Title IX coordinator is housed. Call your school district to get that information, but yes, they are required to do that. If they don't, and you've called them and you've verified they don't have one, you can file a complaint with OCR, because that is a Title IX requirement. And they're also required to notify you of that. Go ahead.
Yeah, so I wanted to just jump in and add that one of the requirements, as you just said, is for schools or school districts to notify parents and students and teachers of who that person is. And so I think we would strongly recommend that schools put that information on their own school websites and not just assume that students and parents are going to look at the district website. Even if you don't have a designated Title IX coordinator in your school building, you should make that information available. Who is it that's designated for your district, who students and parents can go to if they have a problem? Maybe put it in the student handbook, but certainly at least on the website. And it's ideal if a school does appoint someone in the school building, because if that person is visible to students, students are more likely to reach out to that person if they know who it is and they know how to find them, as opposed to finding the school district office and, you know, approaching an adult they don't know. So I think the ideal would be to have them at both the district and school level, and I know some schools are doing that.
Great. And our next question is from a K through 12 school or a K through 12 school district. Is there any standardized training that can be provided for staff and faculty on Title IX? Is there a place, to access that?
This is Lara. We actually sometimes do trainings for school districts and states on Title IX obligations, and in those trainings we typically cover not just pregnancy but also sexual harassment, athletics, etc. So that, I think, is one option, and I think the OCR regional offices also conduct some training. Is that right, Rachel?
Right. Yeah, that's right, Lara. If you are connected to a school district or a state or somebody who wants training on Title IX at the K through 12 level, you can certainly contact the regional office that serves your state, and our offices do technical assistance presentations. There is no type of formal standardized training that OCR sponsors. I know some outside groups have sprung up for the post-secondary level, but that's not something that's connected to OCR. But our regional offices do technical assistance.
Great. And now I know we touched on this a little bit, but can a student athlete lose their scholarship by disclosing that they're pregnant to their coach?
No. Actually, OCR wrote a Dear Colleague letter about this back in the, I think it was before the Obama administration came into place. I think there was a problem at the time with some college athletes who were playing basketball who were actually terminating their pregnancies because they were afraid that their coaches would find out and they would lose their scholarships. And when all of this came out, the NCAA adopted a detailed policy about the treatment of pregnant student athletes. And OCR also issued a Dear Colleague letter to all schools and universities that lays out the requirements in terms of treating pregnant athletes equally and allowing them to maintain their scholarships even if they get pregnant. So that's a good resource to know about.
Great. And our next question is about what can schools do for parenting students who need to breastfeed during the day?
Lara,
go ahead.
Yeah, Lara touched on this. I just wanted to point out that although it's not required, we at OCR strongly recommend that schools would designate a private room for parenting students to breastfeed, pump milk, or address any other needs related to breastfeeding during the school day. Obviously, we want these parenting students to be able to stay in school and continue their education, and that is a big issue that comes up. So we certainly strongly recommend that schools consider this, and Lara touched on that as well.
Yeah, I think it's key that they need to have a clean private space that's not a restroom in which to either breastfeed or express breast milk, and they need to be able to take breaks of a reasonable duration on the schedule that they need, and that may change over time as their child gets older. And so we need schools to be somewhat flexible about those needs. It's going to be very individualized. It's going to be different for every student. And so schools need to work with students to make sure that they are getting what they need and that they can do what's best for their health and their child's health while still staying in school and staying on top of their work.
Great, and we have time for a few more questions. This next one comes from a faculty member at a school for at-risk teens, many of whom are pregnant and parenting. And they want to know how does the school designate someone as the Title IX coordinator? Is there a formal process to make sure that person is connected with the appropriate training?
It's up to the school to make that decision themselves. They don't have to get approval from OCR or anything like that. But you do need to keep in mind that whoever is designated as the Title IX coordinator must be trained, should have appropriate training on all issues related to Title IX. It would be pregnant parenting students. It would be certainly sexual harassment, sexual violence issues, and any the grievance procedures that your school uses to handle Title IX complaints. So part of it is knowing how your school processes the complaints and Title IX issues, and also knowing about Title IX generally. And it would be good for that person, if they don't have that prior knowledge, to reach out to the OCR regional office that serves their state for technical assistance. And then make sure that if you are designated by the school, that the school notifies the community about that information.
And I want to add that
let me just,
OCR has on our website the reading room, which has guidance organized by our different statutes. We enforce Title VI, which is race discrimination. We enforce 2 disability discrimination laws, and we enforce Title IX. So if you're new to the Title IX coordinator role, or you just want to get deeper, we've got guidance on a whole range of topics, including the things that Rachel was mentioning. So you can spend some time there getting acquainted with all the rules and how we apply them.
and I wanted to add, we also have resources on our website on a lot of the areas of Title IX that people should feel free to use and consult. I also wanted to say that in case people are confused about this, the Title IX coordinator, that doesn't have to be somebody's full-time job. So you can designate a school counselor, a teacher, and somebody who has this responsibility on top of their current duties. So you don't have to hire somebody new to fill this position, although of course that would be terrific if you could.
Okay, and one last question to close out the webinar. At the university level, students who have temporary disabling conditions can receive accommodations through the Disability Services Office. Who do pregnant or parenting students go to on campus if they need to request accommodations?
In our experience working with students at various colleges and universities, it doesn't seem to be uniform from school to school. And, that is a problem. And some schools are not excusing absences even for students with disabilities, which, could be its own legal violation, and I'm not a disability rights expert. But, I think it would be great if schools were to make it clear who students should go to if they have conditions that require some accommodation. Do you have thoughts about this, John and Rachel?
Yeah, it's not, OCR likes to give schools flexibility where we can, so it's not something that's set out that a certain office has to do that. But you should certainly make it clear in your policies and inform students who they would go to if they're pregnant and they need those reasonable adjustments. And also just to make clear to understand that a pregnant student who is having a non-complicated pregnancy would not fall under your disability program. They wouldn't be considered to have a disability. So it would likely be a separate office from that disability office. It might be, your student resource office, or maybe where students go to get accommodations or extra help, extra academic services, something like that. That might be an office where you might think would have the knowledge to be able to handle this.
And what I would add is that you clearly heard throughout this that one of the main points is that schools need to treat pregnancy like other temporary medical conditions. So the other sort of way to ask that question is, what does the school do for anyone else who has a temporary medical condition? For the student or whatever, breaks a leg, or gets mononucleosis or something like that, and has to have some special conditions, treatment, whatever, and it should. The pregnant student should have access to the same procedure.
And I will just jump in here and say that, echo that and add that the only area where that's not the full story is in the excused absence area, where even if the school doesn't have a policy regarding excused absences for everybody, they still have to excuse absences related to pregnancy according to the regulations.
Yeah,
right. And just to jump in on that, I saw some questions that, schools are responsible for making sure that their individual teachers, faculty at the post-secondary level, teachers at the K-12 level, that they understand that that is the Title IX requirement related to pregnant students. So, teachers can't have their own policies on excused absences that conflict with the Title IX requirements for excusing absences related to pregnancy and related conditions. It's the school's responsibility to make sure their faculty and teachers understand that.
Okay.
Great. Thank you all so much for joining us today. We hope that you found this informative. I'm sure you did. When we end the webinar, a short survey will pop up, and we'd really appreciate it if you give us a little bit of feedback so we know how to improve our webinar for next time. And I hope you all have a great rest of your day.
Thank you so much.
Thank you.